the people bring lawyers, and then there are also practices that PIOs sometimes they don't come themselves. But as I told you, there are some directors and then collectors, they themselves are PIO. Then they happen to send their juniors. But there is a lot of problems, because if somebody represents them, I happen to penalize. So it may be not possible to implement until unless he comes himself, he presents in person. So that was one of the reasons why so many hearings sometimes takes place. Sometimes if PIO comes, and then complainant comes, then no problem. Some cases within a few minutes we dispose of. But some cases, sometimes appellant do not come, sometimes PIO do not come. So like that, it keep on pulling. Then like this, five times they don't come. So there is no alternative. So just to ensure his presence. So that warrant was inevitable on our part.
Issue summons and
then, but the first thing is, and then we give so-called notice also. Then especially when you penalizing the officers, PIO, so-called notice has to be given, and he himself has to explain why it will delay. Suppose sometimes, I'm not discouraging the lawyer, sometimes what happens, lawyer comes representing, but he cannot answer everything because he doesn't hold the information. Information being held by the PIOs, public authority. They know that where is the papers, how, why, and then just simply that giving, until unless that PIO himself come, he agreed, yes, I am going to furnish this information, this is available, by accepting by lawyers who have experience. So they not serve purposes, and then later on PIO says, no, I don't know, lawyer is not being informed. That's why we make mandatory, at least once PIO must come in persons. Otherwise, we don't leave it, and then,
I think we had a ruling from the High Court of Odisha on this when we insisted that the PIO should be present. The High Court ruling was against us, saying that when a representation was made and the lawyer appeared, the Commission has, not done the right thing by insisting that the PIO should be there. So therefore, the representation is allowed, and so then, in that case, so far it's a penalty case. Invariably, I have not seen the face of the PIO.
I have one case.
Mr. Tripathi had raised the issue about, as you said, a private body. I was faced with something like this. As far as representation is concerned, the view I take is that anybody can come for the appellant or for the respondent. And I am not bothered so long as they come with a letter of authority and say that, sir, I am representing so and so. Even if they come with somebody else, I am quite happy to let the other person speak. But I don't adjourn. Whether it's a lawyer, top lawyers come, they say we want an adjournment, I tell them, sorry, I'm not adjourning. They say, sir, all courts adjourn. I say, then go to a court. As far as I'm concerned, I'm not adjourning. But you mentioned the issue of a private body. Now, I was faced with something similar. This was a school, an aided school, and they had not provided information. The PIO never actually turned up. When I looked at the case, the PIO never turned up. So first time I gave an order saying give information by so and so date. 3-4 months later, the appellant said there has been no compliance, I have received no information. So I issued a show cause. PIO never came. Since he didn't come, I take the position that an opportunity of hearing has to be given. There need not actually be a hearing. The law says you must give the person an opportunity of being heard. So once I've given the person the opportunity of being heard, if he doesn't want to say anything, I can then proceed on the paper. So I penalized this man 25,000 rupees. Still no reply. This chap didn't get information. And then the school wrote to the Department of Education saying that this fellow is a manager, the PIO of that school, and he doesn't get draw salary. Ordinary काम करता है. Now that, when I got that reply, I had been foxed for a day. And then I came to a very simple conclusion. If you are penalized, it's not that I need to pay you a salary. If you are caught somewhere and you have to pay a penalty, you have to pay a penalty. So we wrote again to the school and said, look, if you don't come, it was a slightly threatening letter. So his manager came and he said, sir, I have not provided the information. I have not brought any 25,000 rupee check. But we think we are going to go to court. I said, go to court. I mean, that's your legal right. Hey, you should have gone to court already. Since you haven't, I think you will have to do this. And I said, look, I was also wondering, I said, what the hell do I do to this man? And what can I threaten him with? It's a private school. This was a blast, if you call it, but I told this chap, I said, I'm going to tell the Department of Education to stop your raid. So do your worst, come next week. I gave him a week's time and said, look, you come with a 25,000 rupee check. I want the chairman of your school to come because he's also been summoned. And what I had done incidentally is I had issued a summons. It was not an arrest warrant, I just issued a summons and therefore he came in response to the summons. I said, I want you to come next week. And I also wasn't sure what's going to happen. But sure enough, the chairman came, this fellow came, they came with a 25,000 rupee draft and the information. And I realized why they had been so obstinate. The chairman of that school gave me his card, his personal card. He was personal assistant to one of the top opposition leaders of this country. So I think he was banking on his relationship or whatever. But I think the summons by itself does work. I have not yet come across anybody, so far, and it can happen of course, who refuses to respond to a summons. I mean, the worst case what I do is when a person doesn't appear and I need his presence, I've issued a summons and so far, at least in Delhi, it seems to work. I mean, you issue a summons, people are not willing to challenge your summons, they turn up.
In this case, summons was issued, but this did not turn up. Show cause notice was issued, no reply.
Then I think it is
one moment. So then 25,000 fine was there, still no. What happened was, subsequently we found out that this particular trust was dissolved by the High Court, and High Court appointed somebody somebody as caretaker or something. So he happens to be a lawyer, advocate. So he says, oh, it's right, I will not come. So what we did, the decision which we took was, we will file a contempt petition before the High Court for having himself written the commission which has got his powers. Now, the moment he came to know that the contempt proceedings have been filed in the High Court, he went and obtained a stay order against the whole thing. So this is where the matter stands.
okay. What stays, I think none of us can do
The
other way of ensuring the presence of the opposite parties, do we have followed?
One is that most of the orders are not having compliance obligations in their orders. Like the file is generally closed but by just passing the order. They simply order and close the file, and so there is no direction to compliance the order in order to reopen the file or maybe representation from the department or the applicant, say after 1 week or so. So maybe we can discuss that also in this scenario, because if compliance issue, period can be given.
No, it is all my orders give a specific date for compliance. Every order.
No, but
just a minute. And sometimes it's not compliant. Now the whole issue is this whole lovely word called continuing mandamus. Let us understand. And I think unless we address this issue, the RTI activists themselves will take RTI. It is necessary that most appeals and complaints that come before commissions, and therefore you must look at the commissions where there is a lot of RTI activity. I mean, saying great things about things where the RTI activity is very low, and then holding it up and saying, look, all of you do this, you will land up like courts with years and years of pendency. Personally, I'm taking a conscious position that compared to having pendency, whenever somebody complains of non-compliance, we take up the issue. It's not that we don't take up the issue. But this call of continuing mandamus and trying to satisfy each appellant, I think is a dream which can be fulfilled by, on the other hand, disposing much lower numbers and therefore ensuring that your pendency mounts to a stage by which RTI is finished.
No, but my question was
If I can take the continuing mandamus aspect a little later, we look at the arrest aspect, summons and arrest. Now, when an application is made, you issue notice. The standard approach is to issue a notice, right? Now, under the Civil Procedure Code, when a suit is filed, since the provisions relate to a suit, what you do is you issue summons to a person. Now, what you seem to have is a notice which goes, then you wait, like the Arunachal Pradesh Commissioner says, he waits, then he issues summons that you have not appeared, etc. And then ultimately you go and do the arrest procedures and so on. Now in the suit procedure, it's much simple. You just issue a summons. And I don't know if there's any specific form prescribed in the rules or regulations. It's simple that an RTI application is formed. Prima facie, the court, the commission has decided to look into it. And therefore we issue you notice stroke summons, you can say, to appear in person or through a lawyer. Once you do that, then you don't really have to wait and again. Now you may, like I think Shailesh you do, you give a person a second chance saying
No, I don't give a person.
Okay.
If a person doesn't, no matter who comes or doesn't come.
No, I'm talking about the arrest part now. Suppose you need the person there for some reason to produce a document.
There is summons. And then
correct. Now, actually, in the civil procedure code, there's no separate procedure. There's just a summons that goes initially, which says that this is notice stroke summons. You are required to appear. If you don't appear, either directly or through counsel, an arrest warrant may be issued to procure your presence and to secure documents and so on. So you are advised to come. So once and for all, your notice stroke summons is a comprehensive summons to the person. Now he doesn't appear. The civil procedure code allows you now to straight away in your discretion issue a non-bailable warrant. You can do it straight away. You may, if you want, issue a second notice and say that this is to inform you that you have not appeared. So now we are giving you notice that you will be arrested if you don't appear on the next year. Warrant will be issued if you don't appear. So the procedure actually is very clear. And it's not necessary for you to wait 3, 4, 5, 6 times, then try and get him again, then try and give him a notice again and so on. If the initial notice is very clear that if you don't appear, you can be, a warrant of arrest may be issued, then go ahead and that will quicken.
Here, you may take this notice itself with a summons, because here very clearly we write
or the commissioner who is hearing the matter.
No, it is registered. It is sign will go name of the registrar.
Okay.
But under the SD of this concerned commissioners.
What would be the option for commissions that do not have registrars but only secretaries?
Please pardon?
If the commission does not have a registrar and there is only a secretary who is a bureaucrat, then who will sign the
He is designated as
Can I clarify?
Because there is no power for delegation of authority in the RTA. That's the problem.
No, Venkatesh, look, this power is only with the commission. It is not with the registrar, it's not with the secretary. So if anybody else signs, it has to be a delegated. Now the power is not delegated. See, you have a format in the government, I don't know if you use it, saying I'm directed to. So the signature can be even the PM, it doesn't matter. But it is in the name of the commission that thing goes out.
Order has to be information commissioner. It can be issued by registrar or grand registrar.
But can I, now that, see, I'm not quite sure why we